equivocation that the guarantee issue was material in his decision-making process, and that he had regard to it in making the decision. The argument in the High Court was an argument which was focused on weight, the reinforcing rationale. And I've shown your lordships the way in which the Secretary of State put his case. But that, with respect, is an entirely different issue, weight, to whether it was material at all. As far as the Secretary of State was concerned, it is, I submit, clear that he did give it some weight. It was material, and to that extent, a reason. I've taken your lordships to the parts of the judgment where the High Court indicated that it was either not material or the decision, the preference decision, was not in any way prejudiced. But I respect this bit. That's the reasons I've indicated, the finding which cannot stand. And I said I would provide the proposition to support the position we were taking in that regard, and I do say in the following way.
Yes.
With regard to concessions, a court can allow a concession to be withdrawn only if it's fair and just to do so, having regard to whether allowing the concession to be withdrawn would cause prejudice to the opposing party. One of the things that has happened with the authorities bundle here is that it has had a substantial slimming, and that explains, to answer my Lord Justice Singh's question about Unilever, for example, why it's not there, because the proposition was not an issue. We can supplement the bundle.
No, it's entirely fair, and you're perfectly entitled to point out, Mr. Kingston, that in the list of agreed issues or propositions of law, the parties simply set out those paragraphs in the Divisional Court's judgment. So it's something that has arisen from the court, at least from me, and it may be a bad point, but I'd just like to be reassured.
Of course, we shall provide copies of Unilever to add to the bundle. And,
or any other case which is a better authority for you.
Well, among the others might be Begby, which I think is in the bundle.
Correct.
I will check, and as I've said, if necessary, a short explanatory note of our position.
Thank you.
So I make that point, my Lord, because the point I've just made about concessions and withdrawal, there's no issue about that as a point. So the authorities which are cited in our skeleton will have them, we'll provide copies if you would like them, and not in the bundle because it's not an issue.
No, well that's fine. I don't, certainly Unilever and perhaps Begby would help us, but I don't think otherwise we want to add to our.
And of course, on the concessions issue, there's been no application to withdraw. If these are properly characterised, as we say they are, as concessions, no application to withdraw. Even less, therefore, a reason to not to have regard to.
Right.
The operation, this is the second point, of that position with regard to concessions has to be understood, we submit, alongside other fundamental principles of law. Firstly, the court is to ensure that the parties are on an equal footing, something the CPR embraces, that a party is entitled to know the case of its opposing party. And something we've referred to already, the court will adjudicate on the issues which are in dispute between the parties. And finally, with regard to concessions, it's perhaps appropriate in the light of the authorities to indicate the difference between concessions of fact and concessions of law.
Yeah.
It clearly is the court's duty. However, the parties might agree the propositions of law, the court
It's the court's most fundamental duty,
Absolutely.
or one of the court's most fundamental duties.
But, yes. But here, I have made it plain, we don't think that there's anything in the law which causes the problem. Here it's the concessions, the factual matters which we're emphasising. In my learned friend skeleton argument, it's paragraph 51, for the purposes of this appeal.
Do you want us to look at that?
Yes, if you would.
Yeah. Yes.
Paragraph 51. You can see it's being said at the top of page 19, the continuation of paragraph 51. In reaching this conclusion, the court has accepted the suspicions of the Secretary of State to the effect that while the scheme-specific or subjective reason related to written assurance was taken into account by the Secretary of State, this reason was not ultimately material to the decision to designate the ANPS. With regard to that submission, we make the following points. First, the statement shows that the Secretary of State continues to accept that the guarantee issue was taken into account by him in making
Sorry, Mr. Kingston.
Howdy everyone and welcome back to Us Broadway US.
Let's pause for a second. Thank you.
I'm always conscious that there, but for the grace of God, go I with some electronic device. But nonetheless,
We should ensure that your submissions are heard.
thank you.
That is absolutely basic.
Thank you. So, my Lord, as to that proposition, the first point, the Secretary of State continues to accept that the guarantee issue was taken into account. Secondly, it is, we submit, quite wrong for the Secretary of State now to assert that he made a submission to the High Court to the effect that the guarantee issue was not material at all to his decision. As we have just been through a series of references to demonstrate, we submit it was absolutely plain. The Secretary of State was saying it was material, and that taking it into account was therefore appropriate and lawful. He was not saying that he did not take it.
This is why, I may be wrong, and if I am wrong, I'd certainly like to be put right, but it was the use of the word subjective in that sentence which interested me. Because it may be that the submission, and it may be this is what the Divisional Court held, I don't know, is that it doesn't matter if the subjective reasons include taking into account the written assurance, if, as a matter of objective analysis, it's not material. That may be what's being said, but I don't know at the moment.
Well, I can only say I shall wait to hear with interest, because in the light of the way the case was put,
Yes.
and we've summarised it, it was, we submit, being made plain on any basis,
Yes.
whether subjective or objective or any other, this was material, and I took it into account.
Yeah, and I think you go on to say that take each of those two alternatives. One, if it's a subjective test, well then you submit the decision is clearly vitiated by an error of law because something which is legally irrelevant was taken into account.
Yeah.
Secondly, you submit that if it's an secondly you submit it's not a purely objective test. And that's why I gave the example of the red-haired teacher. That if the local education authority in Short and Poole Corporation had said, we are dismissing you because you've got red hair, it wouldn't have mattered, you submit, that they might have had all sorts of good reasons to do with her conduct or something, why they could have dismissed her lawfully.
Precisely. Once the unlawful reason is taken into account, it matters not that there are other, whether they're called objective or not, other lawful reasons which could have justified the conduct. I'm going to come to that issue, promoter-specific and scheme-specific distinction.
Yes.
I hope quite soon, in order just to demonstrate that the court was wrong
Yes.
in drawing that distinction, and wrong in saying that the Airports Commission did not have regard to all matters, including promoter-specific matters. But,
Thank you.
my Lord, let me get to the third point about this paragraph 51. I say that it reveals, through a lack of logic, the fundamental flaw in the approach taken by the High Court. That the High Court accepted, and the Secretary of State continues to accept, that the guarantee issue was taken into account. Absent evidence that a matter was positively treated as irrelevant, it's illogical to say at one and the same time that it was taken into account but not treated as material. Nor is that, I respectfully submit, a distinction which is readily recognisable as a matter of law. The quotations from the Secretary of State's pleading, skeleton argument and submissions show that he was not saying that the guarantee issue was irrelevant. He positively asserted it was relevant. And if we look at the High Court judgment in order to see what I think with great respect is some confusion, we can see that our point is made good. Looking at paragraph 134 of the High Court. Could I ask your lordships to read it through?
Yes, of
and
course.
then I'll come back to
Yes, no, we shall do that, of course. Yes, thank you.
Right. Third line, the Secretary of State clearly considered the deliverability risk as a result in respect of the ENR scheme to be high. It is equally clear that those concerns are not the result solely of Hal's lack of willingness to support a competitor. Hal had also had the technical concerns with the scheme as identified in paragraph 35 above. The Secretary of State was also concerned with the additional risk with the ENR scheme as the inevitable result of its novelty and the fact that it had not been worked up as much as the other two schemes. So there we're seeing language which I respectfully submit is making it clear as we've submitted that the guarantee had a role. And paragraph 134 appears to be acknowledging that. The references to solely, also, additional risk are, we submit, obvious indicators. And the fourth point about this paragraph 51 is that it appears, as the High Court did, to align the question of relevance, whether the guarantee was taken into account at all, and was thus a reason for the decision, with the weight that the Secretary of State ultimately attached to it. That, we submit, is impermissible. But once it's established that the absence of the guarantee was relevant and a reason, then the issue of weight becomes, we submit, immaterial. We're not here to argue about how much weight the Secretary of State gave to the issue. What's clear was that it was a material issue which he took into account. He treated as relevant.
Yes, this is not one of those perhaps rare cases where a material consideration was explicitly given no weight, which is a concept recognised in one of the planning cases, Tesco. It's not that kind of case. you say.
I do.
Yes. Well, I mean, on the face of it, that is what appears to be so.
Yes. Then, my lords, I said I'd go on to deal with plainly wrong, even if, as a matter of law, it was open to the High Court to find that the guarantee issue was not a reason at all for the Secretary of State's preference decision, and accordingly being put to one side. We submit that the court's finding was plainly wrong, and we start here from a position in which all of the evidence is documentary. So this is not a position in which the Court of First Instance has had to listen to witnesses, hear them cross-examined, judge their demeanour and the like, in order to make findings of fact. All of the findings here come from the documentary evidence. And in the additional authorities bundle, supplementary authorities bundle, your lordships have Henderson, Foxworth.
Ah, this is the slender bundle, yes.
The slender bundle, yes. It should be behind the tab saying 42-1.
Okay.
The facts of Henderson and Foxworth appear from the opening paragraph of Lord Reed's judgment here. If I may, I will not read them out, but leave the court to be informed by them in due course. From our point of view, the relevant paragraphs, most relevant paragraphs, are 57, 62 and 67.
Paragraphs.
57, 62 and 67.
Thank you.
Sure.
Make sure, I beg your pardon. Yes, 57, I beg your pardon.
Yes.
57, 62 and 67.
Yes.
So 57 should be sidelined.
Yes.
Which is?
Just read 57.
Yes, as my lord points out, this must be reported, I think, and if we could in due course at least have the law report.
Yes.
But anyway, 57.
Yes, 57. And bearing in mind, as will be apparent to your lordships when you look, this was a witness action that all ordinary had heard evidence, heard someone cross-examined and had to make findings based on those matters.
Yes.
And then 62, if you would please. Correct identification.
The test is perversity, essentially.
Yes, otherwise characterised as plainly wrong. But may I
Or no reasonable judge could have reached is the
Yes.
final word, so
Yes.
it's clear.
May I add a caveat to that, my lord, please? By reference to paragraph 67. Paragraph 67 starts by saying, paragraph 66, having referred to the earlier authorities, it follows that in the absence of some other identifiable error, such as, without attempting an exhaustive account, the material error of law, the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence, an appellate court will interfere with the finding of fact made with the trial judge only if it's satisfied the decision cannot be reasonably explained or justified. That's the rationality point. But the rationality point is preceded by the examples given by Lord Reed, and I hope I've made it clear here that we say there is a material error of law in the making of here a critical finding which has no basis in the evidence or demonstrably misunderstands the relevant evidence or has failed to consider it. So, my lord, I'm happy to accept the irrationality point, but it's important to see that it is preceded by those errors of law, and as our skeleton argument makes clear, we rely here on errors of law in the court's approach.
Sorry, your formulation, forgive me, I'm behind you with my note. No basis in the evidence. Did you say then contradicted by it? How did you put it? I'm sorry.
Well, I'm afraid I simply read from paragraph 67.
I see, you're reading from there, yes.
I'm simply taking paragraph 67 points. With I hope some intent.
No, sorry, so I see you are, yes.
Yes.
I got it now.
You say pretty much every error identified there by Lord Reed was committed here.
Yes. For the reasons which I've earlier explained, with great respect to the approach which was taken in the court below.
Yes, they're not mutually exclusive categories, are they?
Yes, the only thing that Donahue reminds me is, of course, slightly worse here in the sense that these were concessions which were being made by the Secretary of State in terms of his position. He was conceding. I did take it into account.
Right, so where there's a conscious concession, conscious and deliberate concession, that intensifies the rationale.
Yes, it does. It may, well, and it goes back to what I've said was an error of law, that the court should not depart from concessions of fact as distinguished from concessions of fact in circumstances where there's not only no application to move away from the position, but the opposing party has been given no opportunity to then argue that it would be inappropriate. Here we have the concessions in the way I've described it.
So in a if I'll call it a litigation context, in a proceedings context where there is a deliberate, conscious and deliberate concession, you say that that is a fortiori, an exemplification of what Lord Reed said at paragraph 67. Is that right?
Yes.
You say, don't you, that it's a hard-edged matter, because if there's a concession which hasn't been withdrawn, the court shouldn't go behind it,
No, it shouldn't.
leaving aside 67.
Yeah.
It's an error.
It is an error of law.
No.
Yes. So the starting point for the court ought to have been here that the guarantee was sought. That's the agreed paragraph 31 of the agreed factual narrative, and sought as a guarantee. Having sought it, the Secretary of State chased it up, as you'll see, by his private secretary, dealt with in the judgment, paragraph 56. And subsequently, the Secretary of State repeatedly referred to the absence of the guarantee in explaining his decision. We perhaps ought to note that the court's conclusion with regard to the Secretary of State's approach at the 25th of October Cabinet meeting was a conclusion which it was not supported by the evidence here from Miss Lowe, or indeed by any other evidence. Here, the Secretary of State had a briefing paper, and of course been referred to, it's referred to as the factual narrative. But when he went to the subcommittee meeting, he had a speaking note. But when he spoke at the meeting, the record of what he said, irrespective of what was in the briefing paper or the speaking note, is contained in just one place, paragraph 599 of Ms. Lowe's first witness statement. The Lordships have that in the supplementary bundle.
Do you want us to look at that?
Yes.
Yes.
Volume 3, tab 62. Page, I hope I got the bundle page right, 1123.
That's right.
This is a convenient way of seeing on the same page, 598 is what the speaking note said, and you can see there were separate matters identified in the speaking note, but there's a quite separate point at the end. I have also had no certainty that the airport will deliver the scheme if we choose it. The point before is dealing with operational certainty, less confidence about capacity. Quite a separate point. That's the speaking note. The record of what actually was said at paragraph 599.
The speaking note, sorry to interrupt you, but the speaking note was not produced at the meeting, is that right?
No, I think it was a Secretary of State.
Yeah, I mean, that's what I would assume, but it wasn't actually, as it were, laid on the table at the committee meeting.
Let me just check
Yeah.
that. To be sure about that. But
I mean, to be fair to Ms. Lowe, she doesn't say that it was.
No. But what the Secretary of State actually said, 599,
Yeah.
and may I just give you the reference? This is said in the third witness statement, because we said we'd like the minutes, and you can imagine having the minutes, there was a contribution to that. So a third witness statement was sworn. You've got it at tab 67, page 1298. This is said to be a complete and accurate record of the discussion. And you can see the points A to F.
Yeah.
My notes will read them, but you'll see that E is a quite separate point. Hub had been challenged to provide written confirmation from Howell confirming they would adopt the UNR scheme should it be chosen. No such confirmation has been received. And that's a separate point to deliverability, capacity, F, what might be characterised as the novelty point. So E is a quite separate guaranteed point. And then paragraph 600. In summary, the Secretary of State set out a number of reasons why the NWR scheme was preferred.
Yes,
He did say by providing and so on.
your point is that whereas in the speaking note it might be said to be a bit of an add-on, what also in 599 what was actually said at the meeting was that it was one of 6 factors.
Yes.
Simpliciter.
I may say, although 599, it's I have also had, it is undoubtedly in the speaking note was featuring as an issue and a separate issue. But when you come, as my Lord correctly says, 599 to what was actually said, it's quite clear. And 600, a number of reasons. And what is clear, and the High Court appears to have been a little confused about it, the Secretary of State did not adhere to the view set out in the paper which had been presented as part of the subcommittee papers. Conveniently, just a few pages back at 1121 in the bundle.
Yes. Yes.
consistent with the Airports Commission's view. This is not an issue which will, the agreement issue, not something which will cause a difficulty. It will ultimately be resolved. The Secretary of State did not adhere to the position taken in the paper. And that matters because, as we'll see when I've been able to locate the reference, the High Court said that the Secretary of State had downplayed the issue of the guarantee in what he had advised the committee, and they refer to this paragraph. I'm afraid I've foolishly put the reference to one side, but the important point from my point of view is to see that the advice in the paper and the advice in the paper and the departure from the advice in the paper in what the subcommittee was being told. If you go in the judgment to paragraph 63, you can see paragraph 63. It is said that the issue was downplayed, but as you can see from the note of what was actually said at the meeting, the Secretary of State certainly didn't downplay it. Anything but, he identified it as a separate reason. Distinct from others relating to capacity and the like. He took a line which had not been supported by the Airports Commission.
And you say it is not a Secretary of State merely going off script. But what he said can be taken as being the authentic basis for his decision.
Yeah. In part,
Yeah.
not only because of what he said, and that, if you'll forgive me just to rewind the narrative, prior to the 17th of August, no one has said there is an agreed position. This issue is not going to feature in advance of the President's decision. The 17th of August, our new Secretary of State says, I want you to get a guarantee. He pursues it through his private secretary. He gets to the Cabinet subcommittee meeting, departs from what's said in the paper and says this is a separate issue and it's a disadvantage of this scheme. On the same day he goes to Parliament, you will have read the parliamentary references, he goes to Parliament and says that one of the fundamental reasons is there was no guarantee. And then just over a year later, when he's before the House of Commons Select Committee, he says, as I have said earlier, one of the major disadvantages. So the narrative is clear, and it's clear that for the Secretary of State, this was a, you could choose any one of the adjectives he chose, a fundamental, a big, a major reason. And he was consistent in that throughout. And it's important to note, consistent throughout, with no indication prior to the designation decision that he made any attempt to say, well, I think I might have gone somewhat awry here. I know I've said this earlier, but, so there's no undoing of any of that. And in relation to what he said to the subcommittee, and not, I beg your pardon, to the select committee in February 2018, the day after, I think it's the day after, the Secretary, and your Lordships got the letter in the bundle, the Secretary of State wrote to the chairman of the Select Committee and said, I've reviewed the transcript and I want you to have a clear, I paraphrase, a clear and accurate understanding of our position. And he did not say anywhere in that letter, I think I probably mischaracterised what I said about our reasons for the rejection of the hut scheme. I know the transcript recalls me saying this, but I think I've expressed myself wrongly. No qualification at all. So, from our perspective, we have a clear narrative. First, 17th of August 2016 to last February 2018. This was an important issue for the Secretary of State, which he took into account in the decision-making process, and he was wrong to do so.
Well, you say a clear and consistent narrative.
Yeah, I do. My Lord,
And you also say, just have, that the context is important, that it was raised by this Secretary of State distinctly for the first time. Nobody else had. And that adds weight, you say, to the to his later clear statements, that it was in fact his thinking.
Yeah, it was his point. I hadn't taken your lordship's to it, but you'll know that for the 17th of August 2016 meeting with the Heathrow promoters, including Heathrow Hut, the Secretary of State was given a briefing paper. It told him, I think in 3 places, he should be in listening mode. It gave him lines to take and told him how he should explain the government's position, fair, equal for promoters and the like. It gave no indication at all that anyone, either his predecessor or anyone in the department, thought there needed to be something by way of guarantee. So we know where the point came from. It emerged for the first time at that meeting, and thereafter was pursued in the way we've described. My lords, if I'm not to trespass on Mr. O'Donoghue's territory, I need to make a little progress if I may. We have made submissions in relation to the High Court's approach and the infringement of Article 9, which your lordships will recollect, if I can summarise the position. In essence, what we say the High Court did was to say, well, let's have a look at what the Secretary of State said in Parliament. Well, we think what he said in Parliament means this, and because on our construction of what he said in Parliament, that's the same as what he said outside Parliament, we don't need to admit the contentious parliamentary material in support of our conclusion that this was a non-material issue. We respectfully submit that that is a straightforward infringement of Article 9. What the court should have done was to have ruled on the admissibility issue and then considered what the language meant. What it did was to consider what the language meant, construe it, and I say construe it in a way which at the very lowest questions, to borrow Article 9 language, questions what was said, and then having construed it in that way, then said, but we're not going to admit it. That is an error of law, a breach of Article 9, not a course which was open to the court. My lords, then, very briefly, if I may, ex post facto rationalisation. One of the things that the High Court did here was to prepare a rationalisation, or draw on a rationalisation, in support of their finding about the Secretary of State's position, which drew a distinction between what was called objective deliverability, constraints that are inherent in the nature of the development, and the scheme-specific constraints, and constraints which are a consequence of the nature of the promoter-specific constraints. Your Lordship will have seen it, our skeleton deals with it, it's paragraph 17 of the judgment. The court accepted that none of those distinctions were distinctions which had been drawn by any of the parties before it. So what we have is the court constructing an approach to the issues, a rationalisation of them.
This was simply the court trying to conveniently categorise the distinction between the necessity, as you say, the Secretary of State put it, of getting a guarantee, and all the other factors which went generally to deliverability.
But what? I do beg.
So simply a categorisation.
Well, it was a
Convenient.
It was a categorisation, but if I may say so with respect, not simply, because it led the court then to an approach which separated the issues. So, for example, the court said, well, the Airports Commission wasn't concerned with promoter-specific issues at all. So the first time these issues came to be considered was when the Secretary of State began to look at them in his post-Airports Commission final report in the second half of 2015. That's simply not correct. It is not correct that the Airports Commission did not look at what the High Court called promoter-specific issues, and that's one of the reasons why we've provided the other additional document in the bundle. I don't have the bundle reference, but it's the Airports Commission. Its title is number 16, Delivery, Risk Assessment and Mitigation. It should be in the additional documents bundle. Tab 16A.
So it is.
So this is an Airports Commission document.
November 2014.
Yeah.
Yeah.
So pre-final report. If I may, paragraph 1.1. That's the introduction telling you what it's about. Section 2, Risks and Mitigations, 2.3. And I draw attention to the last sentence. The report highlights the key potential risks and possible mitigations identified by the Commission at this stage. Some risks are common to all proposals. On these risks are reflected where necessary. The primary focus is on distinguishing factors between the schemes. So that's what the Airport Commission is about here. And then if you go, you see section 3 is Gatwick. Section 4 is Heathrow Airport Extended Northern Runway. 4.1, the Commission's work to date has identified the following risks in respect of Heathrow Airport Extended Northern Runway scheme. And if you go to the bottom of that page, you'll see they dealt with novel runway concept. And consequences of that at 4.5 were factored into Chapter 11 of the final report, with a consequence in the concluding sections of Chapter 11 of the final report that actually it wouldn't affect the delivery date. But from the point of view of what would, under a subheading of commercial risks, paragraph 417 and following, if you go to paragraph 419, one of the matters taken into account, transfer of scheme design may present risk. The scheme design has been devised by HHL and is not owned or endorsed by Heathrow Airport Limited. The transfer of any relevant intellectual property may require commercial negotiations which could present a risk to delivery timelines. I respectfully submit it could not be plainer that the Airports Commission had regard to what the High Court characterised as a promoter-specific risk. So that when it wrote its conclusions in the final report, chapter 11 and the concluding paragraphs, I think 1153 and following, it had regard to all of those matters. And in relation to this ex post facto rationalisation, it's important to see that it never was the Secretary of State's case that the Airports Commission didn't deal with any of these matters. He never said, look, the Commission didn't engage with these things, this is all perfectly correct. So, my lords, it was factually wrong. It fed into an approach which, in the end, the court used to support a distinction, which in reality in the decision-making process had not existed. The Secretary of State, for example, didn't say, speaking note, or actually in the meeting, I've divided these risks into this sort of categorisation because the Airports Commission approach or anything. My lords, at the end of the day, it produced, from the High Court's point of view, this ex post facto rationalisation, the introduction of this distinction, produced the error which we have identified in no reason. Decisive. And it was decisive. My lords, I'm keen not to trespass on Mr. O'Donoghue's time. Unless your lordships have any questions of me, I shall leave him to make progress with the other grounds.
No, thank you very much.
Thank you very much.
Yes, Mr. O'Donnell, please.
Lords, I will deal with grounds 1 and 2, which are the European competition grounds. In a nutshell, my lords, these concern the state's obligations not to distort competition on a market. The European treaties have a series of such obligations. The concept of state aid may be familiar to your lordships, Articles 107, 108 of the treaty. There are obligations of sincere cooperation under Article 4.3 of the Treaty of the European Union. The obligations we're concerned with here concern Article 106 of the TFEU, which in a nutshell prohibits state measures in the context of public undertakings or privileged undertakings that distort competition. So the gravamen, the infringement, is the offending state measure.
Yes.
My Lord, with your permission, I'm going to very quickly go through the architecture of the judgment on these points.
Yes.
Then give you the essence of my submission as to why they're wrong, and then develop each of the two grounds in a bit more detail.
Yes. Thank you.
Well, if we can turn up the judgment in the core volume 4.
Well, we've got it separate, so just give us the paragraph numbers.
Okay. So we're going to start at paragraph 157, 158. So there you will see the underlying treaty provisions, Article 106.1, which I've just summarised, and 157 you'll see where it's Article 102. I'm sure you'll also see this up, but the way Article 106 operates, it applies in conjunction with another treaty provision, in this case Article 102. So that's the foundational treaties. Then, my lords, at 159 and 160, you will see the subconditions teased out in a bit more detail, and with one exception, that does not take issue with anything said here. Now, the one exception is at 160 little 4. The court says, has the undertaking in fact infringed Article 102 of the state measure? In my submission, one goes back to 159 little 4. That is not fully correct, because at 159 little 4 they say it is not necessary for public undertaking actually to have infringed Article 102. It is sufficient for there to be a risk or potential for an abuse of the acts taken by the member state about that potential. So that's an important clarification. But subject to that, I trust these matters are common ground.
So can you just show us the words "in fact" again?
So it's 166 Roman 4.
160.
160.
160 Roman 4
Yeah.
Yeah.
has the undertaking in fact.
Yeah.
My submission that needs to be read to like 159.
Before we leave that page, are you going to make submissions to us about paragraph 162?
Well, yes, that is one.
That seems to be quite crucial to the divisional court's reasoning.
Well, no, it is one of the main points made by the Secretary of State.
Indeed.
I live with that. Well, continuing with what the judgment found, so the four conditions we saw 159, 160. So they found the requirement of dominance was satisfied. That is paragraph 178. They found the requirement of privileging was met. That is 182. And they found the existence of the state measure. That is paragraph 184. So the critical finding of the division court's purpose was the fourth condition, which is the risk of abuse. So to put it another way, Hub was 75% successful in terms of the subcondition, but lost on the fourth cumulative and decisive condition. That's the subject of my submissions today.
Yes.
Now, so I'm focusing now on this fourth subcondition, the risk of abuse. If I can take the judgment's findings in two parts, starting with 189.
Yes.
So essentially, you will see the lack of materiality found by the court in the context of the other judicial review grounds was essentially recycled in the context of the fourth subcondition in respect of abuse. And Mr. Kingston, I think, has shown you the cross-references of 137 and 138, and I'm proposed to go back to those unless the Lordship would like me to do so.
Do you also emphasise 190?
Well, yes, that's the next point I'm coming to. So having cross-referred to 137, 138, say, given those conclusions, it's impossible to see how any abuse of domination could arise in the part of how the state measured the request by the Secretary of State could in any way enable the abuse. This is an inevitable consequence of our findings that the request and response to it had no effect on the preference decision. That is the case, whatever Howell's state of mind, were not providing the commitment requested by the Secretary of State sought by the claimants. And then at 192 over the page, similar point, the short point is that there is not even a potential anti-competitive consequence liable to result from the state measure in this case. So that is the first one. Now my submission in essence is that is based on a clear error of law, because the distortion of competition in question had crystallised in full at the point the request was made by the Secretary of State on the 17th of August 2016. And the point is a very simple one. In our submission, the request for a guarantee in the context of the competition where Hub and Heathrow had competing schemes gave the competitor in an important competitive process the opportunity to inject conflict of interest considerations into the structure of competition on that market. To put it another way, while the competition was pending, it was effectively a two-horse race at Heathrow. You could not have one of the horses essentially having something tantamount to a veto, or at least a say in the fate of a competing bid. That is a structural problem of competition in the market at that point. And the legal point I wish to make good on the back of that is again a very simple one. It simply does not matter whether after the 17th of August 2016 the guarantee was actually taken into account, or even that Hal had actually refused to provide a guarantee. Now, as it happens, Hal did in fact refuse. But it is clear beyond question from the cases I'm about to show you, Lordships, that the crystallisation of the distortion of competition at the point the state measure is enacted is sufficient in law for the distortion of competition to arise. Whether there's any actual effect in terms of subsequent events is neither here nor there.
Let's suppose you're right as a matter of EU competition law. How does that get you into the Judicial Review Court to quash the ANPS 2 years later?
Well, one can look at this a number of ways. So, my starting point, of course, is that if Mr. Kingston is right in terms of materiality, then I'm in anyway.
Yes.
But if your lordships are against Hub on that point, in our submission, it is relevant in any event. First of all, if one looks at this as a competitive process, I mean, the preference decision and the ANPS, these are mileposts in the context of an ongoing competition. And we submit that if, during the currency of that competition, on or about the 17th of August 2016, which is only a couple of months before the preference decision, there has been a distortion in the competitive process for the market, for the competing scheme, the winning scheme. That is an infection that continues in the process right through the preferencing and up to and including the ANPS. It is an illegality that cannot be cured by the suggestion that there was a subsequent lack of effect or taken into account. It is an enduring distortion of competition in that competitive process.
Even if, on this hypothesis, it might be immaterial.
Well, yes, because the problem with the Secretary of State's argument, I mean, it's really a bootstraps point. If I'm correct in law, which I will show the court very shortly, that the need for an actual effect in terms of the taking into account of the conflict of interest is not a requirement of the 106 case law. It is a bootstraps point to say, well, when I got to the preference decision, it turns out I put this out of my mind, or certainly by the time I got to the designation decision, it was out of my mind. The distortion has occurred, has crystallized in fact and in law, and that is sufficient for my purposes on a prospective basis going forward.
But the Divisional Court make the point that this isn't a self-standing competition claim. It is a judicial review claim. And my Lord's point is that we have to look at it through the prism of judicial review, where ex hypothesi materiality is important, is necessary.
Well, Lord, there is a judicial review point. I mean, if one goes to section 13.1 of the Planning Act, it says that anything done or omitted to be done in connection with the policy statement is the subject of judicial review. And perhaps this is a convenient moment. If we go to the fourth authorities bundle.
I'm sorry, just following my Lord's question, it would help me at least for you to formulate in public law terms the alleged error of law on these two grounds.
Oh, yes.
In public law
In
terms.
public law terms.
Yes.
So my starting point is that there is an infringement of Article 106. One, read in conjunction with Article 102. So that is the question of liability.
Sorry, let's get this down carefully. Infringement of Article 102. Yeah.
106.1 read in conjunction with Article 102, which are crystallised in fact and in law not later than the 17th of August 2016.
Take this a little slower for us. Crystallised by no later than
17th of August 2016,
Yeah.
when the guarantee was sought. And the reason I make that submission is, at that point, the conflict of interest, the distortion of competition from a structural perspective on the market, was manifest.
yes.
And the subsidiary point is whether or not, in fact, there was an actual effect in terms of the how the refusing to give the guarantee, or the Secretary of State actually taking into account, it is neither here nor there. The substantive illegality at that point is crystallised. Now, putting this in judicial review terms, we do rely on Section 13.1 of the Planning Act, which says that anything done or omitted to be done in connection with the policy statement can be the subject of judicial review. And one can look at the points in two ways. One can treat the seeking of a guarantee as an illegality done in connection with the NPS, or one could equally treat it as an omission, in that the Secretary of State, by asking for the guarantee, failed to secure conditions of undistorted competition in the market, the competition for schemes, for the expansion of capacity in the southeast of England. And
Well, it's one and the same thing, isn't it?
well, to put this in public law terms, that is the jurisdictional hook, if I can call it that.
Well, your jurisdictional route is through section 31. Is it?
Well, that is a question of relief, which,
Well, what's your route into a public law challenge?
well, Lord, we are entitled under Section 31 of the Planning Act 2008 to raise by way of judicial review anything done by way of illegality.
Right. So the answer to my question was yes.
Yes.
So it's section 13(1)(3)
Of
of the Planning Act 2008.
Yes.
That's what you're relying on.
Yes.
Procedurally, that's the gateway into this court.
Yes,
When-
and
when-
Lord, we can turn this up to your lordship's wish, but the judgment of Mr. Justice Cranston in Hillingdon claim shows that had Hub come to the High Court by way of judicial review at the point of the preferencing decision, they would have been struck out.
Why is that?
Well, his finding is that the appropriate time under Section 31 to proceed by way of judicial review is after the policy statement is handed down. Well, perhaps it's useful to turn that up. It's in Authorities 4.
Yeah.
It's tab 51.
Tab 51. I'm very familiar. So this was actually a challenge in this case by the Hillingdon Borough. And we can essentially get the important points from the headnote on the first page. So you see a reference in the first sentence to the preference decision, NPS, and so on. Then about 2/3 of the way down, Section 31 of the Act amended by the court might entertain proceedings for questioning NPS or anything done or omitted to be done by the Secretary of State in the court preparing the NPS, only if the claim form was filed at the end of the period of 6 weeks beginning on the day on which the statement was designated as an NPS or later, and so on. And then there's an application to strike out that application for judicial review, and the strikeout was granted. And then if we can go forward to paragraph 71. There's no basis in my view to find acts or omissions in the course of preparing NPS to be exercised as Secretary of State or statutory function under the 2008 Act. The Secretary allowed for were characterised as proceeding policy-making function, not subject to the inclusive effect of Section 13. The words anything done or omitted to be done by the Secretary of State in the course of preparing NPS are clear, albeit there might be facts and inquiry as to whether a particular act or omission was in the course of preparing NPS. Parliament intended that those acts or omissions be limited to what is laid down in the 2008 Act, or to a draft NPS, and it said so. Nor is there any grounds for distinguishing between policy statements which have the implementality of the NPS or other policy statements. As not what the Act says, the formulation of a policy might be part of the preparation of an NPS. To draw such a distinction artificial. The statutory net is cast wide, it applies to anything done in preparing an NPS as well as to omission.
I assume there was no appeal against this.
No, it's this case.
That's not dealing with a competition law argument, though, is it? Your submission, based on Article 106, is that your cause of action for breach of the treaty crystallised as at the 17th of August 2016.
And with enduring effects going forward, yes.
But could you have ventilated that cause of action in any other forum?
Well, no, because the only thing we can challenge is the state measure.
You say there was a state measure, which was the requirement of a guarantee.
Yes.
Well, then you could have challenged that. Why not?
In the competition tribunal.
No, because the competition tribunal has no jurisdiction over state measures.
Right.
This could only be brought by way of judicial review.
I see. And you say the effect of Mr. Justice Cranston's decision was that you had to wait until the ANPS.
Yes, we can struck out. And there is a deeply unattractive aspect to this submission by the Secretary of State, because had we gone in October, we'd been struck out until too early. Now we come back after the NPS, and we're told, in effect, we're too late. So, in effect, what is being contended for here is a form of ouster, and it's deeply unattractive in my submission.
Well, not merely deeply unattractive, but wrong.
It's not unjust.
Well, wrong in law.
And there'd be no possibility on your case, is there, of approaching the Commission, the European Commission?
Well, there may have been scope for an administrative complaint, but that would have been a purely discretionary matter.
Certainly, you couldn't launch a direct action.
No.
So the best you might have been able to hope for was that the Commission might take infraction proceedings. Is that right?
Or the competition demands.
Yes, I see.
In
Yes,
this
in this country, yeah.
But the thing we're attacking is the state measure. Now, as I'll show you lordships, once this conflict of interest structure is created, it doesn't matter if HAL is a private undertaking. Does it? It is the structure which is the objection. And in my submission, that even more firmly anchors the proceedings in public law. Now, to put it another way, HUB could not bring a private law action against HAL for taking advantage of a state measure. That is something which inherently sounds in public law and judicial review. So those are the findings on the first ground. Now on the I can wrap this up before lunch. On the second part of the judgment's critical findings, this starts at 194. The court says, out of respect to the argument put on the premise guarantee, or at the very least material, we consider that we should consider, if this were the case, the Secretary of State's request for statements made in House French Article 102. So that the court essentially made an alternative set of findings, that if we were right on materiality, how did that impact on the competition claim? Then at 198 we see the detailed analysis. So at Bill 2, the reason we've given, we consider that this market, so that the market for expansion of development of new airport capacity, includes the development of new airport capacity, such that under consideration by Secretary of State. So that evidently, the Borough reached the HAL in the case of NWR, claimants in the case of ENR, had an interest in seeing its scheme adopted under the ANPS. And then 4, last sentence, HAL promoting its own NWR scheme could have no real interest in furthering the rival ENR scheme, whilst its own scheme was still in the running. And then 6, although we found Secretary of State raised the question of HAL's commitment, we found this had no effect on the preference decision. At least in those circumstances, there can have been no abuse by HAL or HAL's state of mind of thinking. The state measures not in any way enable an abuse of the dominant position. So the critical thing is little 7. They say, however, if we're wrong on this point, and the question guarantee was material, then it interfered with the process of objective valuation of the 3 schemes by permitting HAL to effect the preference decision when HAL declined to provide a commitment to the ENR schemes over the payments to the Secretary of State. It had a material influence on the rival merits of the scheme by depriving them of the material factor in its favour.
So they're making a point in your favour, is that right?
Yes, they're saying if this was material,
Yeah.
then on any view there was a conflict of interest.
Yeah. So the reasoning in the preceding subparagraph, Roman 6, you submit is crucial, because the way they characterise their own earlier finding is that the Secretary of State raised the question of Hal's commitment. That seems to, but they also said that it had no effect on the preference decision. That's really Mr. Kingston's point. That's
Yes.
fundamental misunderstanding of what the facts actually were.
Yeah, so my lord, the mechanics of the judgment mean that if Mr. Kingston is correct in ground 3, subject to one point I will come to, we will succeed on ground 1 as well.
It's inevitable.
It's inevitable. But there is one sting in the tail, which is the subject of round 2. Let me finish this point before we break. Well, just for your record, I mean, the court says this very explicitly in paragraph 200. So, according, if we were wrong, in the end, the state measure will have the opportunity materially to influence the preferences. So there you have the finding in black and white. So the sting in the tail is at 203, 205, and starting at 204, as Mr. Bannifer Aurora made very clear, the nature of this future development, so this is the development consent order, is itself very much going to be affected by rival plans for development consent relating to the NWR scheme. In these circumstances, we consider that it cannot be sensibly be said that the failure on the part of Hal to provide a commitment can it influence the structure of competition in the market, and so on. So the essential finding here, which is the subject of ground 2, is even if the lack of a guarantee had a material impact on the preference decision, the fact that the question of the development consent orders in relation to the NWR scheme remains at large, and they say may give scope for Aurora to get a slice of the cake, means that there is no distortion of competition in any event. And the essential submission under ground 2 is that is utterly misconceived. One cannot say that there is a distortion of competition crystallising on the 17th of August 2016, that is somehow neutralised by the fact that in 2025 somebody might get a slice of the cake from Hal. The critical distortion is that Hub had a competing scheme against Hal's. The fact that in 3 or 4 years' time somebody else may get a slice of the action in relation to Hal's scheme really is neither here nor there.
Well, your submission is that the critical distortion, as you describe it, was a once and for all distortion.
It had completely crystallised. And I mean, we made this point in our skeleton. It's like saying I form a cartel that covers the entire market, but the cartel is lawful because I subcontract some proportion of the activity to a third party. I mean, it's nonsense. If there's a distortion, there's a distortion at that point. It doesn't get neutralised by something which is out there beneath it.
Right. Now, is that a good point at which to pause?
Well, yes. I'd like to go to the conflict of interest cases to make good points.
All right. And how are we doing for time?
Well, I think I have until 3 o'clock. And I would stick to it.
Thank you. 2:05.